Welcome to Property Law 101. I'm Sara Bronin, and I created the series to help you understand the basics of property law. So we cover 4 fundamental questions of property law in this series, and today we're talking about the third, which is using property, or perhaps I should say, restrictions on use of property. So one of the things that property owners can do on their property is place on their properties conservation and preservation restrictions. So what are these restrictions? These are a kind of negative servitude that prohibit people from doing things on their property. Conservation restrictions deal with landscapes, they deal with nature, wildlife, environmentally sensitive lands. And preservation restrictions differ from those in that they typically cover historic buildings or structures. So not buildings are places that are occupied by people, structures, or things like bridges and other elements in the landscape. So typically, these restrictions are held by a nonprofit organization, usually with some expertise in holding easements. So a historic preservation organization at the state or local level, or maybe a land trust might be the kinds of entities that hold preservation and conservation restrictions. Before we get too far, I want to explain the terminology. So why are we using the term restrictions? Some people use the term conservation and preservation easements. And actually, even the federal government uses that term and incentives I'll talk about in a moment. But I prefer to use the term restrictions because even scholars can't decide whether these are covenants or easements. And state legislatures have had trouble with that too. Before we get to that, more on that, let's talk about the content of these restrictions. So what might they say? They might prohibit construction on environmentally sensitive areas. They might prohibit demolition or changes to exteriors of historic buildings or even ancillary structures that might be on a historic site. These restrictions might prohibit subdivision, either under certain circumstances or absolutely. They might prohibit certain uses that constrain or threaten conservation and preservation values. They might actually require the property owner to engage in affirmative maintenance. For historic properties, the standard for affirmative maintenance is often tied to the Secretary of the Interior's standards for the treatment of historic properties. More technical provisions of restrictions include requiring the property owners to insure the property and to indemnify the restriction holder. And finally, there might be mandates for public access or at a minimum access by the organization holding the restriction for regular inspections. So with all of these things in mind, you might ask how long these things endure. Usually these obligations endure perpetually. And in fact, they must be perpetual in order to get tax breaks offered by the federal and sometimes state governments. In some ways, though, that makes conservation and preservation restrictions something of a legal fiction. No building will last forever. And landscapes won't even last forever, especially given the threat of climate change and the increasing threats that are related to that from natural hazards. Moreover, as some scholars point out, we're not really sure that this is even a good idea. How do we really make long-term decisions over particular parcels? And should we really let the dead hand of the people who negotiated these restrictions rule all subsequent owners? Nonetheless, these restrictions have been adopted and even incentivized in every state. It's state statutes that enable these creatures of property law through specific language. In creating state laws, legislatures have recognized that courts are reluctant to accept negative servitudes in common law. That said, the state statutes that allow these kinds of restrictions haven't been around all that long. So Massachusetts adopted conservation restrictions, probably the first state to really do so in modern form in the 1950s. The Uniform Conservation Easement Act was promulgated in 1981. Today, conservation and preservation restrictions are also embedded in laws that provide incentives for their creation. So one example of that is federal law that provides income tax deductions to property owners on the basis of the value of land that is lost when preservation and conservation restrictions are imposed. All right, so there are a lot of issues to discuss here. In fact, I devote full chapters to conservation and preservation restrictions in my historic preservation law books, co-authored with Peter Byrne and Ryan Roberry. But what I want to leave you with now is 3 questions. So first, if perpetual protection of land and landscapes and buildings is really a myth simply by the nature of materials used, what is the purpose of the legal focus on this topic, and what is the purpose of the perpetual nature of these easements? Second, I want to ask you to consider who is benefiting from the benefits that are offered for the creation of these easements. Who's most likely to go through the process of getting income tax deductions for their creation? And last, is there a risk of overprotecting property? So while this is an area of law that might have laudable goals and are much embraced by historic preservationists and environmentalists, I think it's up to you as the next generation of thinkers in the law to consider how conservation and preservation restrictions really work. Okay, so I'm going to leave it there. I would love to hear from you in a variety of ways, Twitter, website, and more. And I will see you next time. Thanks.